Hello, and thank you for viewing my company's overview. My name is Dr. Joseph Grillo, and today I will briefly discuss with you who I am, what my qualifications are, and how I might assist you in the fields of medical malpractice and injury law. To begin with, I am a board-certified medical doctor. My fields of practice include internal medicine, infectious disease, and kidney disease. Overall, I have a diverse experience in the practice of medicine. I've practiced as a hospitalist, where I tended to general medical patients. I also have experience in ICU medicine, bone marrow transplant unit, and cardiac critical care. I am certified in numerous procedures, such as intubation and ventilator management, central line placement, dialysis catheter placement, the harvesting of stem cells, and lumbar puncture. In addition, I have experience as a provider of dialysis. And finally, I practiced infectious disease and HIV medicine in private practice. Beginning in 2009, I opened and operated urgent care facilities, where I garnered experience in acute orthopedic injuries and minor surgical procedures. And finally, I am presently a third-year law student at the University of Massachusetts. My mission is to provide injury and medical malpractice attorneys with the medical support that they require. These services are typically case-specific, with the underlying theme always that I act as a team member who possesses a medical perspective. As a student in training, I approach each and every opportunity afforded me by an attorney-client as a means of developing lasting relationships. You will find that my fee structure is in keeping with these objectives. In order to reach this high bar, I set as my goal simply to provide an excellent service. Over a 2-year period, I can make claim that my clients have indeed been highly satisfied and in general have come to regard me as a valued team member. As your medical liaison, my goal is to fulfill those functions that you request of me. I strive to do so in a professional and unbiased manner. This suggests that if your case lacks merit, I will inform you of my opinion as quickly as possible in order to avoid excessive expenditures. While the issues at hand and the questions that are asked are varied, there is a constant. That is my approach. The analyses and answers provided to you are through the eyes of a highly trained physician. One of the typical tasks that I've been asked to perform is to first conduct an initial inquiry of the medical records, and then, based on the medical facts, to identify all potential acts of negligence. This involves identifying first the standard of care for that particular instance, which in turn may entail a review of the medical literature, and then to posit as to whether there has been a breach in that standard. Establishing the sequence of medical events that amounts to cause and fact does indeed require a medical viewpoint. From this information, we may further identify a number of legal theories in establishing acts of negligence. The issue of vicarious liability is interesting. As you know, there are a number of ways to establish that a hospital is vicariously liable. There are theories of negligent hiring, negligent supervision, and negligent retention as well. In most states, There is also a direct negligence cause of action against a third-party hospital, as when procedures and protocols are defective. I will discuss this in more detail shortly. Vicarious liability becomes important when states limit the amount of malpractice coverage that a physician is required to carry. In effect, this limits the amount that can be recovered. Often it is the case that this maximum permitted recovery will be insufficient to compensate the patient, particularly when there are ongoing harms. It is therefore important during the initial inquiry into the medical records to identify vicarious and direct sources of liability by the third party. There are various legal theories that may be applied in order to hold the third-party hospital to account relative to the plaintiff's harms. One method that has been particularly effective is to examine the hospital's policies, procedures, and protocols. Defective policies and procedures may lead to a causal connection to the harms. The hospital has an independent duty to take reasonable care in establishing sound policies and procedures. If policies are defective, this often will amount to a breach of the standard of care. And so, the medical consultant will always perform this detailed review of the medical records. The remainder of the strategy indeed relies on and is built on this effort. Indeed, to build an effective case, the fundamental requirement is a thorough, painstaking analysis of the medical record. From this, we generate a professional document authored for the legal audience. Indeed, identification of the standards of care is an important step in the process. These standards are often found in the medical literature, and there needs to be a comfort level in studying the medical literature. Having both a medical and legal background has been very helpful and useful in creating the links in the medical events which establish causation. After this, the next step is to determine the degree of certainty that such causation exists. For example, one might state that it is more likely than not that this given sequence of events resulted in harm. To date, I have not seen instances in which causation was 100% absolute. Instead, qualifying terminology must be provided. I re-emphasize the analysis of hospital policies. Independent of hospital policies, there are also hospital procedures and protocols. They all have their relative place. Again, it is generally worthwhile to analyze and critique all of these. Very often, I have found that the devil will be found in the details. I've observed policies that were written only to fulfill JCO requirements and not necessarily to be functional documents which were created to be integrated into medical practice. On the other hand, procedures and protocols are intended to exist for patient safety, and when they are defective, either on their face or as applied, they can actually be harmful to the patient. In addition, policies that are written as procedural should be incorporated through an algorithm which is typically written into the electronic health record. When this does not occur, it is an indication of a breach in the standard of care. Oftentimes, a medical person's perspective is important with respect to developing strategies for the discovery phase of litigation. Finally, there have been times when I have been asked to perform legal research. I am fairly proficient in the use of Westlaw. At times I've been requested to produce properly cited legal documents of varying types. So as you know, my name is Dr. Joe Grillo. I am a medical doctor, and I make the claim that I have indeed mastered my craft. I am accomplished, I'm well trained, I am well published, I have a diverse experience in the medical profession, and I have complemented this experience as I go through law school to become an attorney. You will find a more thorough presentation of my credentials and publications on my website. So, why might you hire me? My experience is that I have been a highly effective team member, that person who has the medical perspective. I can certainly bring you to your bottom line quickly and efficiently. The creation of a consulting firm has been the very reason why I went to law school. Hopefully, you will allow me to serve you. I thank you very much for your time, and I urge you to please contact me without hesitation.